Hi, everybody. We're going to take a minute to get the interpretation going. Let me say once again, good afternoon. We're so happy you're joining us. Welcome to the Governance and Enforcement Lab and Worker Power Table gathering on protected concerted activity with our friends at the National Labor Relations Board. We will be recording the session today. Closed captioning is available. There will be simultaneous interpretation. So let's take a moment now to get the interpretation going. We have wonderful translators today, Sarah Michelson and Brenda Valladares. Sarah will remind everyone now how to access translation on your Zoom.
Ok, buenas tardes a todos. Qué bueno es que todos ustedes estén aquí en una sesión de la mesa de poder de los trabajadores, sesión de aplicaciones del gobierno y hablando específicamente sobre actividad concertada protegida. Vamos a grabar la presentación. También tenemos interpretación simultánea en un momentito y voy a explicar cómo usarlo. Y tenemos subtítulos en vivo. Entonces, para la interpretación simultánea, por favor, hable con despacio porque estamos hablando a la misma vez de ustedes. Y hay muchas palabras muy específicos para el vocabulario. Entonces, en un momento va a ser un globo por abajo de la pantalla. Puede hacer un clic del globo y elegir su idioma de español. O si está conectando con teléfono, va a ser 3 puntitos al abajo de la pantalla y puede hacer lo mismo, hacer un clic para elegir español. Gracias por estar aquí. So, hi, my name is Sarah and Brenda is here as well as an interpreter. And we, as someone mentioned, we're doing simultaneous interpretation. So try to speak not too quickly because we're speaking at the same time as you. The way to access it is in a moment, once we turn it on, there will be a globe at the bottom of your screen. And you click the globe and then choose English. Or if you're joining us by phone, there will be 3 little dots and you click that and then choose join English. And thank you for having us. I think we'll turn on the interpretation now.
Fantastic. So we also have 2 polls that should pop up in just a moment. So if you could take a minute to answer them, it will help frame our whole conversation. So fabulous. So the first poll, how often do you see cases where workers have experienced or been threatened with retaliation? And then you have a choice: always, often, sometimes, rarely, and never. Sarah, do you want to? Great. Okay, so if people could answer that, that would be fantastic, and submit. And then there's a second poll once people have had a chance to answer the first one. So again, the first poll, how often do you see cases where workers have experienced or been threatened with retaliation? And now, Jake, would you mind launching the second poll?
I believe we'll have to do this one first, and then we can go over the answers,
okay.
And then I can launch the second.
Okay, great. All right, wonderful. So do you want to, has everyone voted? Do you want to put up the results? Okay. Yep. Right, so we can see that that always is 18%, but that we have often and sometimes. So with these all together, right, 18, 54, 25. So overwhelmingly, people are contending with retaliation. Okay, so Jake, now would you launch the second poll? Are your state or local government's policies and practices adequate to provide relief to workers who have experienced retaliation? Well, we have pretty much 100% participation and 100% saying no. So this is the context in which we gather today. So it just gives us a little bit of a grounding in this conversation. So I'll just say again, thanks so much for joining us. This session is co-hosted by the Governance Enforcement Lab, the National Legal Advocacy Network, Jobs with Justice, and I'll say that the Workers' Justice Lab at Rutgers University and Jobs with Justice created the Governance Enforcement Lab as a space where a group of worker centers, economic justice organizations and coalitions, legal advocates, policy wonks, and researchers can come together to dig into how to build powerful governance and enforcement mechanisms into their local and state policy proposals, and to partner with enforcement agencies, all in ways that build worker power and drive standards and structures and organization back into local sectoral labor markets. Today, we've opened up our community to a larger set of organizations to learn together about this important topic. We all know that employer retaliation is a huge problem, and that fear of retaliation is what keeps workers from organizing, asserting their rights, and coming forward. The goal of this conversation is to learn about the Protected Concerted Activities Clause of the National Labor Relations Act, a powerful tool for fighting retaliation, whether a worker is involved in a union organizing campaign or not. We're going to begin with an overview of what protected concerted activities are under the NLRB, under the National Labor Relations Act, what a protected concerted activity violation looks like outside of a traditional union organizing campaign, and look at how it can be used to address or prevent retaliation, and focus in on preventing retaliation for immigrant workers. We need more tools and more options. That's what we want to hear about today. PCA is not widely understood to provide protections beyond when there's a traditional union organizing campaign, but the National Labor Relations Board is very eager to change this. As Mori and Teresa will describe, protected concerted activity protections are much broader than that. For example, when even just two workers talk together about work-related issues, how they are not being paid the minimum wage, for example, that's concerted activity and they are protected. The National Legal Advocacy Network, NLAN, reached out about doing a training on this topic just as we were starting to plan as well. So we've been really excited to combine forces and bring our networks together. Ellen?
We've got a really great session today. We're super excited that you're here. We're so happy to have Mori Rubin, who is the Regional Director for Region 31 in Los Angeles, and Teresa Poor, who's the Assistant Regional Director for Region 29 in Brooklyn, here with us from the National Labor Relations Board. They're going to give us an overview of what protected concerted activities are and what potential violations look like outside of a traditional organizing campaign. We also have Sheila Medali, who's here from the National Legal Advocacy Network, who's going to ground us in how you can use this in your organizing and advocacy work. Also Rayos Burciaga and Gabriela Ibanez Guzman from Somos un Pueblo Unido in New Mexico are going to give us a real example of how this works on the ground and the claims that they have filed. Finally, the wonderful Jessie Hahn from the National Immigration Law Center will dig into how these rights can be used to request deferred action for immigrant workers involved in labor disputes. So we've got a really packed schedule. We're gonna try to move through it fairly quickly. And we recognize that also that there's a range of experience in the room today. Like some people, this is the first time you're hearing about protected concerted activities, and some people are really familiar with this work. So we're going to try to make this conversation relevant to everyone. And we're so excited to have you here. And I'm going to turn it over to Teresa to get us started.
All right. Thank you, everybody. Thank you for inviting us. Janice and Ellen, thanks for looping us in. And the synchronicity here was nice. I didn't know that you guys were all having a conversation about this in the background. Let me get started. First, I want to let Mori say hello so you can see her on her video.
Hi. So yeah, and I also want to extend my thanks for being invited to participate in this. I'm really excited about it.
Yeah. Okay. So as usual, we'll launch with our PowerPoint. Since you already were introduced to us. Yeah, so I'm from Region 29, Brooklyn. We cover Brooklyn, Staten Island, Queens, and Long Island. But let's just get right into it. So today we have a couple of goals. As Ellen and Janice already mentioned, what we're going to do today is we're going to introduce you guys to, some of you will be introduced, some of you, you already know about this. But we're going to introduce you to the National Labor Relations Board and the General Counsel, kind of what the institution is. Then we're going to talk to you guys about the heart of the National Labor Relations Act, which is protected concerted activity. Hopefully along the way, we'll show you how broad it is and also dispel some myths along the way. And then we're going to talk about some tips or how to pursue a case with the National Labor Relations Board. The poll that was launched, the 2 poll questions that were launched was really interesting, especially the second one. If you're seeing lots of retaliation, but you don't get a lot of good retaliation enforcement from your state or city labor standards enforcement agencies, the National Labor Relations Board, we're kind of built for retaliation. That's what we do. So hopefully by the end, you'll understand that a bit more. Go ahead, Mori.
Okay, so we wanted to, as Teresa mentioned, we wanted to first introduce ourselves as an agency. The National Labor Relations Board, NLRB, is an independent federal agency. We're not the Department of Labor. People often get us confused. And our agency has 2 primary purposes. The one is that we conduct elections so that employees can determine whether or not they want to be represented by a union. And that's what most people know us as doing. But we also investigate and prosecute unfair labor practices, and that's our focus today. Our agency has a 5-member board, and they adjudicate unfair labor practice cases that work their way up to the board after a hearing before an administrative law judge. And this is the 5-member board that interprets the National Labor Relations Act and issues decisions. And the board members are appointed by the president for rotating 5-year terms. We currently have 3 Democrats and 2 Republicans on the board. And our case law tends to change quite a bit with administrations. The agency also has a general counsel who oversees work in our 26 regional offices as we investigate and litigate unfair labor practices. And the general counsel has an extremely powerful role in determining what issues are going to make their way to the board for consideration to change the law. Our current general counsel, Jennifer Abruzzo, who was appointed by President Biden, has a very expansive view of employee rights under the NLRA, and she's aggressively seeking to protect those rights to the fullest extent possible. So it's a really exciting time at the NLRB. She is committed to intergovernment agency collaboration and coordination to ensure that the government as a whole is co-enforcing the laws in the most effective and efficient ways. Hearing the answers, I guess we've not yet achieved that, but I'm hoping, we can. And Jennifer Abruzzo, the general counsel, also recognizes that immigrant workers are especially vulnerable to unfair treatment in the workplace. And she's directed us in the regions to try to obtain all possible remedies to ensure that immigrant workers get the fullest possible relief. The immigration unit, we have an immigration unit in our headquarters and immigration coordinators in each region. And we're going to discuss it later, but it's important to know that we don't conduct investigations unless a charge is filed. And although we cannot impose penalties for violations, we can remedy harms that are caused to the collective effort. So Teresa is going to talk now a little bit about who we protect.
All right, you guys, we will be getting to the PCA part, but before you understand protected concerted activity, you need to understand where our authority extends. So we have jurisdiction over most small businesses, private sector. We don't cover public sector employers. So we don't cover government workers, et cetera, but most small businesses we cover. Workers at not-for-profits, we cover. Workers in right-to-work states, we cover. If they're working in the private sector, it is highly likely that we cover them. On occasion, there are some employers that can kind of sneak underneath our jurisdiction, which is established by revenues, the amount of receipts and money they get. But for the most part, we can capture most everybody. So also, this is important, and interestingly enough, I was just talking with some folks from the Mexican consulate. They oftentimes will get callers from Mexico and trying to talk about some problems they're having at work, but they believe that because they're immigrants, they don't have rights, even at the Mexican consulate, like they won't talk. So it is really important for us to repeat this over and over again, is that workers are protected under the National Labor Relations Act, regardless of immigration status, regardless of your document status, you're protected. You're a worker. There may be a few remedies that we'd have to create for you, but we'll get to that in a second, but you're protected. There are a few exclusions. Agricultural workers, from the very start of the National Labor Relations Act, when it was passed, they were excluded. Now, this is if they're actually doing the harvesting. If they're working in factories that are associated, we could probably cover them. Independent contractors, if they're true independent contractors, we may not be able to cover them. We won't be able to cover them. But don't assume that if somebody is labeled independent contractor, that they're really independent contractors. They're probably workers or being misclassified. But if they're true independent contractors, then we don't cover them. Domestic workers. Now, the key here is that domestic workers from the very beginning of the National Labor Relations Act, they were also excluded. But these are primarily domestic workers who work for families. If they work for something like Mary Maids or Amazon or a big company, we would probably cover them. Okay, so our authority extends to the private sector. We cover most employees and most employers. But what is it? What is the thing that we protect? The thing that we protect, we call it at the National Labor Relations Board, and what it's called PCA. It's Section 7 of the National Labor Relations Act. It's protected concerted activity for mutual aid and protection. What does all of that mean? When the National Labor Relations Act was passed, there's this preamble that at the heart of the National Labor Relations Act, there is an assumption there that there is an imbalance of power between employers and employees. And that one of the ways to rebalance the scales is to allow employees, like employers get, the right to associate, the right to collectively raise their voices at work. And all of the public has an interest in this. So protected concerted activity is the right to basically create power at work, right? And so the way that it's described in the National Labor Relations Act is, one is you have the right to engage in basically group efforts to improve your wages and working conditions or your working lives. We call that protected concerted activity. You have the right to determine, as Mori said, whether you want to be represented by a union or not. Sometimes when employers ignore your collective demands, they just blow you off. Some workers will need to get a union in order to bring the employer to the table. You have the right to collectively bargain with the employer. And then you also have the right to refuse to do these things. So the key thing about Section 7 is, number one, it's the heart of the National Labor Relations Act. It is the power upon which unions are created, but it's also the power upon which I think a lot of you guys experience that in your own campaigns. It sits at the heart of probably most everything you're doing. And then there's the right to refuse to do it.
Just want to jump in and say we have about 5 minutes left for this.
Okay, Mori, go.
All right, so just some quick examples of protected concerted activities. 2 or more workers talking to each other about their wages or safety concerns, that would be an example. Employees have a right to discuss their working conditions with their coworkers as well as others, including the press or a worker center. PCA, protected concerted activity, encompasses the right to engage in social justice advocacy when it's aimed at improving working lives, such as attending a Fight for 15 rally or possibly wearing a BLM insignia. There has to be some connection between the social justice issue and working conditions for it to be protected. Workers filing wage theft claims, workers deciding to protest discrimination at work, or workers telling the employer that the work is unsafe and refusing to do that unsafe work. Those are the types of activities that we protect.
So what does retaliation look like? And I know Janice mentioned it's like retaliation in a non-traditional organizing. Firing, demoting people, reducing hours. Those are traditional. Transferring an employee to another location. Contacting law enforcement, including ICE. Imposing new paperwork requirements on somebody. Making working conditions pretty much less desirable. Threatening, promising, basically anything. We call it an unfair practice because the employer is using its power to intimidate the worker or intimidate the group of workers. So those would be examples.
Okay, so for filing charges with us, it's free. Anybody can file a charge with us. Either we have a great website online. It's on the slide, www.nlrb.gov, or any of our regional offices. We want you to know that we have information officers and translators available. Please keep in mind that we have a 6-month statute of limitations, which means that a charge has to be filed within 6 months of the alleged unlawful conduct. And the person or the organization who files the charge becomes our point of contact as we gather evidence and as we communicate about our determination and ask for decisions to be made with respect to the case, including settlement. When a charge is filed, it's assigned to one of our, Teresa, can you advance the slide? to one of our board agents who's going to take sworn affidavits from the witnesses, first the charging party witnesses, and then from either the employer or the union if the charge is filed against a union. If we decide there's merit to a charge, the first thing we do is try to settle the case. And so, for example, if there was unlawful conduct that involved a discharge, we're going to try to get reinstatement for the employee, back pay, reimbursement for consequential damages. And that would be something like, for instance, late fees on a loan because you lost your job and you could no longer make the payment. We also require that employers post and distribute a notice to employees, telling employees about their rights and stating that the employer will not interfere with these rights. The notice also will state what the employer has to do to remedy the situation. Recently, we've been also trying to obtain in our settlements a requirement that there be training to employees about their rights or training of supervisors and managers about employee rights and about employer obligations. If the case doesn't settle, then we issue a complaint. One of our attorneys litigates the case. Charging party can have their own counsel, but they don't have to. And then the judge issues a decision. It can be appealed to this 5-member board. If we don't find merit to the charge, then whoever filed the charge will have an opportunity to withdraw it before we dismiss it. And our dismissals can be appealed. Just wanted to mention a couple quick practical pointers. Thank you, Teresa. So be sure that when you bring witnesses into one of our offices, be sure the board agent knows what evidence you want the board agent to get from the different witnesses. Let us know in advance if you're going to need an interpreter. If a threat or an interrogation occurred at a group meeting, we're probably going to want to speak to more than one employee to get corroborating witnesses. We are aware that employees are really reluctant to cooperate with our investigations. And one thing we can do is issue what we call a friendly subpoena or an investigative subpoena to the witness so that the witness feels covered, that they're cooperating with us only because they were subpoenaed to do so. So ask the board agent about that if you think it would be helpful. Our process sometimes takes time. So a tool we have is called a Section 10J injunction. And in that circumstance, while the case is working its way through the after the investigation, but through a hearing before an administrative law judge, which could be several months down the road, then you wait for the decision, then the decision could be appealed to the board. During that time, if there's going to be irreparable harm, because in the meantime, the situation is not being remedied, you can ask that we seek an injunction, which means we go into federal district court. Our region got 2 of these within the last few weeks, where a judge gives temporary relief and gets that person back onto the job while the case is working its way through our process. So ask the board agent about injunctive relief if you think it might help, or you could also ask for that on the face of the charge. That's really all. given our time
Okay.
constraints. I think that's really all.
Yeah, we can stop and just sort of let Jessie and everybody else talk, and then we'll
Okay.
lace everything in.
Yes, we'll be taking questions for you two in a moment. What we thought we'd do is invite Sheila Medali from the National Legal Advocacy Network, our dear comrade and colleague, just to say a little bit. Sheila has done a lot of trainings on protected concerted activity and worked with a lot of organizations. So she's going to just share a slide and say just a little bit about how community organizers, labor organizers, worker centers, and others can use PCA. So can we put that slide up?
Sure. Thanks, Janice. Thank you to Teresa and Mori also for joining us and sharing that presentation and really taking the time to kind of walk organizers, advocates, those of us in the movement through the work that NLRB is doing. It just absolutely warms my heart to see all of these wonderful people on this webinar talking about building worker power. If I am talking too fast, just interrupt me and I will slow down because I like to talk fast for translation and closed captioning. But I just wanted to take a minute to emphasize some of the strategies, both that Teresa and Mori highlighted, as well as some others that are kind of used in organizing campaigns and that might trigger protection under the NLRA. And so this is like by no means an exhaustive list, and really would love and hope we get to the point later in this webinar that folks can kind of share other strategies that they've used about using protected concerted activity. But just to get us started, want to share a few examples, so of common strategies. One being demand letters. And so these are letters that are kind of created usually by a group of workers that outline shared concerns, shared desires of change in the workplace. These letters are often signed by workers or a committee of workers. And it's this act of signing and delivering the letter to the boss that really kind of makes it known that the workers are engaging in this concerted activity. And it's often an early step in an organizing campaign, and specifically usually in a workplace organizing campaign that will trigger this kind of PCA protection. For folks who haven't had experience with this or just would like to see templates, we have a ton of different examples of demand letters, and I'm sure many of the other organizers on this call also do. So those are resources that are very much available to you. Another kind of common strategy that we've just really seen increase, has been social media actions. And so this can range from launching a coworker.org petition or kind of Twitter storms using Instagram, Yelp, any real social media platform to broadly share a coordinated message and kind of move workplace demands. And so here I would just kind of flag that, and kind of reiterate actually what the NLRB folks flagged about, making sure that anything that is shared via social media or any other publicly disseminated way is not false, nor is it disparaging about the employer's brand, and making sure that it's related and kind of based in working condition concerns. And the reason for this is that, these statements, if they're false or disparaging, may not be protected. And so it could open up the organizers as well as the worker leaders to legal claims by the employer. So really just kind of recommending that you kind of stick to what you know to be true and, focus on workplace conditions and kind of related conditions. I think another common, very common strategy is kind of canvassing outside the workplace and other places. But similar to social media, it's really important that what you're sharing is based in fact and focused on the workplace. Here we'll also kind of just flag reminder about like where you are physically standing and to avoid any sort of issues with trespass or interference with the business operations. Again, to avoid any sort of liability for the organizers or the worker leaders. Often another common strategy or thing that occurs during organizing campaigns, worker meetings. So as mentioned, protected concerted activity generally kicks in when there's 2 or more workers discussing their workplace concerns. So, group conversations about workplace concerns, the formation of a worker committee, these things can trigger protection. But, to be protected from retaliation, there needs to be some showing that the employer is reasonably aware that these meetings or conversations were happening. And so for this reason, we'll often kind of see and recommend a more formal meeting or the formation of something like a worker committee that has a name and a designation to kind of demonstrate that there is this structure and there are these meetings and shared concerns and conversations happening. Similarly, meetings with the boss, we really recommend that workers try not to speak to the boss one-on-one, especially if there's an organizing campaign. And this is because, both just solidarity and power in numbers, but also because of the, concerted activity protection that kicks in when 2 or more workers are sharing a working condition concern. I will mention and flag that an individual meeting with the employer can be protected concerted activity, specifically when the individual is kind of acting on behalf of a group of workers, sharing a concern of a group of workers, or preparing for some sort of group action. So it is possible, but generally still recommend 2 or more workers. Also here, just like a reminder, when thinking about groups and formations, a reminder that supervisors are generally not protected by the NLRA. Another kind of common strategy is taking legal action around working conditions. So as mentioned, filing agency charges, can be protected concerted activity. Our kind of feeling and thought at NLAN is that, that legal strategies alone, only get you so far, and really recommend coupling this with organizing to kind of have the broadest impact. And then there's also kind of more escalated strategies like work stoppages, slowdowns, strikes, all of which can be protected. It's important to note if there's a no strike clause in your employment contract or anything else that would kind of prevent that from being an action that is possible. And also just to flag there, if that's a consideration of a strategy, to think about, the purpose of the strike and what the ramifications can be. Like really short version of it being, if there's a strike about an economic reason, like wages and working conditions, employers may be able to permanently replace the workers. If the strike is about an unfair labor practice, then generally speaking, employers cannot permanently replace the workers. But there's much more nuance. So just kind of flagging that it is an area that is protected, but maybe to feel free to reach out to us or others if this is a strategy you're thinking about. And then, going all the way, and there's so much in between here, but also forming a union, it's clearly protected under the NLRA, but also, for worker centers that are on this call, if this is something that, you are thinking about adding a C5 to your organization or working with the union, there might be some C3 organizational issues implicated. So while this absolutely is something that could be considered, recommend that you kind of feel free to reach out to us, or I know Charlotte Noss is on this webinar, the folks at Rutgers, but a lot of folks here can kind of point you in the right direction just to make sure that, whatever you do does not put the organizers, the worker leaders, or the organization itself at risk. And so I feel like this would be a great time to actually move to reality. So want to pass it over to our friends at Somos to kind of share, what it looks like in practice and how they've used concerted activity in their organizing campaigns.
And so we'll just say thank you to Gabriela Ibanez Guzman and Rayos Burciaga from Somos Un Pueblo Unido in New Mexico for your willingness to come and share with us a really powerful example of the use of protected concerted activity. And once we do that, people are putting fantastic questions in the chat. Please keep going, and then we'll turn to your questions.
Hola, buenas tardes. Muchas gracias. Gracias por invitarnos a este gran es súper información. Mi nombre es Rayos Burciaga, soy organizadora comunitaria en el Centro de Trabajadores en Somos un Pueblo Unido en Nuevo México. Y yo voy a hablarles brevemente de cómo en Santa Fe, Nuevo México, hemos organizado a cientos de trabajadores utilizando esta Ley Nacional de Relaciones de Trabajo y cómo por medio del proceso del NLRB muchos trabajadores han podido cambiar sus políticas en su lugar de trabajo. A través de este tiempo se han recuperado cerca de $2 millones desde el 2012 que se abrió el Centro de Trabajadores aquí en Santa Fe, en sueldos robados y sueldos caídos. La mayoría de esto ha sido porque hemos utilizado esta ley. Estos grupos han actuado, la mayoría de estos han actuado colectivamente, tanto para poner sus quejas de robo de salario o en algunas ocasiones han sido grupos que han sido, como dice nuestra compañera, ¿verdad? Que se han organizado y han tomado represalia en contra de ellos, han tenido un proceso por medio del NLRB y han podido regresarles su trabajo, pagarles lo que es sueldos caídos. Antes de hablar específicamente de lo que nosotros hacemos, yo voy a comentarles dos casos, ¿verdad? Dos casos, ¿cómo se dice? Dos maneras, ¿verdad? Una, los trabajadores que son organizados, que se organizan como un grupo, que logran sus pedidos, y la otra, muchos trabajadores aquí en Santa Fe no necesariamente tienen que llegar a una queja para hacer cambios o no han llegado a una queja. Por ejemplo, teníamos un grupo de trabajadores que trabajaba en una fábrica de tortillas. La mayoría eran mujeres y ellas se organizaron, vinieron, hicieron sus cambios, hicieron sus cartas, pero tomaron represalia en contra de ellas. Esto les costó, ¿verdad? Que algunas trabajadoras duraran muchísimo para cuando tomaron sus casos y los regresaran a trabajar. Solo quiero hacer un paréntesis. Voy a hablarles brevemente las historias y luego les cuento el proceso, ¿ok? Para que no se me confunda. Entonces, esto nos ayudó mucho a estos trabajadores porque ellos en todo este proceso estuvimos trabajando, ¿verdad? Desde, como dijo nuestra compañera, perdón, empoderándoles básicamente para este proceso. Entonces, esto es el grupo de trabajadoras que lograron un cambio significativo, no nada más en su lugar de trabajo, sino cuando ellos estaban organizándose. Santa Fe se divide por dos regiones, ¿verdad? Perdón, Condado y Santa Fe. La ciudad de Santa Fe teníamos un sueldo mínimo más alto, pero el condado estaba en un sueldo mínimo más bajo. Entonces, por medio de este cambio, estos trabajadores lograron, ¿verdad? Trabajaron bastante para que ellos tuvieran un sueldo mínimo igual al de Santa Fe. Esa es la parte de esas trabajadoras que hicieron un grupo, que se organizaron, que pasaron un proceso y obtuvieron, aparte de los cambios en sus lugares de trabajo, ¿verdad? Un cambio más significativo, no nada más para ellas, sino para muchos trabajadores en Santa Fe. Esa es una parte. La otra parte son hubo un restaurante también aquí en Santa Fe de un grupo de trabajadores que llegaron. Ellos tenían acoso sexual por parte de un manejador que tenía bastante poder en este lugar de trabajo. Y ellas inmediatamente nosotros les dimos las herramientas, cómo hacerlo, y esto cambió y hasta la fecha ellos no necesitaron poner una queja con la Junta Nacional, de Trabajo. Hubo cambios significativos en su lugar de trabajo y hasta la fecha ellos tienen una política muy específica de acoso sexual. Cero tolerancia a acoso sexual. Ok, esos son los dos ejemplos que tenemos en Santa Fe. Pero antes de darle los pasos, solo quiero recordarles que para nosotros, para el Centro de Trabajadores, es súper primordial cuando un trabajador llega aquí con nosotros, ¿verdad? A pedir información sobre robo de salarios, sobre despido injustificado, que utilizan mucho eso. Nuestra base muy es muy firme es quién más está, no tienes poder, solo no es mucho lo que puedes hacer, ¿verdad? Hay que hablar con tus compañeros, hay que venir, hay que hacer esto. Entonces desde ahí empezamos a empoderarles. Cuando ellos empiezan o nos dicen más bien, ¿verdad? Nosotros, no es que estoy en esta situación, yo creo que no lo puedo hacer porque no tengo quizá un estatus migratorio, porque tantas trabas, es cuando es el momento cuando ellos llegan con este problema, ¿verdad? Que ellos llegan de una manera a veces frustrados, a veces enojados con sus empleadores, a veces molestos. Entonces ese es el momento perfecto para que desde el momento, parte una, nosotros empezamos a hablar con ellos, cambiar un poquito su mente, ¿verdad? Sí, pues si tienes derechos, sí puedes hacer esto, pero mira, hay que hacer esto. Entonces, ¿quién en tu lugar de trabajo o quién más hay? ¿Quién más? Desde ahí es comprometerlos para que ellos, si es la persona individual, para que traiga a alguien más, ya sea una persona, dos más, porque si hay una violación en un lugar de trabajo a una persona, es muy seguro, ¿verdad? Que va a haber 2, 3, 4, 5, 6 personas. Entonces, esa es nuestra primera parte, ¿verdad? Es muy parecido a lo que estaba hablando mi compañera, así es que voy a ser un poquito más breve. La otra parte después de eso es juntarnos ya con el grupo, ¿verdad? Ya en grupo y explicarle, hacer una lista de todas las cosas que está pasando, cuáles son los problemas, soluciones, que son violaciones y que no, ¿verdad? Y desde ahí, desde este momento, decimos, ¿verdad? Nunca les mentimos, nunca decimos esto va a ser muy fácil, esto es así. No, siempre hablamos de la represalia y cómo cómo va a cambiar las circunstancias si están en un grupo, ¿verdad? Cómo es que ellos se pueden proteger en contra de la represalia. Entonces, esa es nuestra primera parte. Después del grupo, cuando el grupo, los trabajadores deciden ellos mismos, platicamos, hablan, quieren hacerlo. La otra parte, nosotros tenemos decimos contrato, pero en realidad no es un contrato. Voy a ponerlo nada más así. No lo quisimos poner, y yo les voy a explicar brevemente en nuestra lista, porque no es un contrato legal. Más bien es un compromiso con sus compañeros y con la organización. Hay 2 puntos ahí, lo que nosotros, que sí vamos a trabajar con ellos, ¿verdad? Ya cuando ellos deciden que sí, que se van a organizar y que ya hablamos de los problemas, a que lo van a hacer, entonces ya es cuando nosotros le decimos, ok, nosotros estamos súper dispuestos, aquí están nuestras oficinas, aquí está nuestro centro de trabajadores, pero sí hay ciertas cosas que nosotros, ¿verdad? Requerimos de ustedes. Por ejemplo, número 1, que se hagan miembros de la organización, porque pues nuestra organización es una organización de miembros y así funciona, ¿verdad? No es nada, no es pagar súper dinero, nada más una membresía de $20 por año, es para estar en nuestra base de datos y ahí ellos ya se sienten parte de la organización. Eso es súper importante porque ellos desde ahí ya se sienten, ya saben que ellos son importantes para nosotros y que nosotros vamos a trabajar con ellos. Número 2, que todo lo que se hable aquí antes de mandar sus cartas, antes de que ellos hagan una decisión, va a quedar privado mientras no se declaren un grupo, un comité. ¿Por qué? Porque cuando vienen a veces muchos trabajadores y todavía no se deciden que ellos sí quieren, no quieren participar a grandes rasgos en un comité, muchas veces estas personas o alguien que estuvo en la junta va, ¿verdad?, a los lugares de trabajo y lleva información. Y pueden despedir a alguien antes de estar protegido o de mandar una carta diciendo que son un grupo, ¿verdad? Y que quieren actuar así. Entonces, no es mucho lo que nosotros pedimos, solamente que vengan a nuestras juntas, que sean parte de nuestros grupos, pero lo más importante es el compromiso entre ellos, que ahí hay unas notas, ¿verdad? Que es entre ellos que no van a tener, por ejemplo, juntas con los empleadores solos, que no van a firmar nada que no van a firmar nada individualmente, obviamente, que si hay algo hacia algún compañero, él no va a tomar una decisión, porque desde ese momento ellos van a actuar colectivamente. Entonces, básicamente ese contrato es un compromiso, más bien no es un contrato legal, no es nada, es un compromiso, pero desde ahí ellos ya relativamente están comprometiéndose. La otra parte, después de hacer el contrato, cuando ellos se van, nadie puede estar en la carta si no está dentro de este compromiso o dentro de este contrato. Nadie que no esté aquí, que no haya escuchado, que no haya leído, que no haya sido parte de esta información, puede nombrarse en la carta. ¿Ok? La otra parte es hacer la carta firmada por todo el grupo.
I just want to... Sorry, I just want to jump in very briefly. Thank you so much. This is really great. I want to make sure we have enough time for questions, Rayos. So if you could wrap up in a minute or two to make sure that we have enough time to answer questions.
Ok, entonces me está diciendo que termine rápido para las preguntas. Ok,
Por
ya
favor.
voy a terminar.
Sí, sí.
Como 2 minutos más, Rayos.
Ok,
para
entonces, ok, entonces la otra parte es obviamente mandar la carta, mandar su carta, ya lo dijo nuestra compañera, ¿verdad? Guardar a nosotros aquí en el centro de trabajadores, les decimos, este es tu expediente, tú eres parte de esto, aquí está tu información, esa es tuya. Entonces, esa es la otra parte, que ellos vayan preparándose por si hay desde el momento les explicamos de pruebas, de que tienen que guardar todo lo que sea pruebas, ¿verdad? En caso de que haya una represalia. Obviamente, después mandar la carta, juntarnos nuevamente con el grupo para saber qué onda, qué dijeron, cómo les fue, ¿verdad? Qué reacción tuvieron los empleadores, qué fue lo que pasó. Y obviamente, en algunas ocasiones, por todo el trabajo que se ha hecho cuando organizamos grupos, porque lo hacemos muy público, porque no lo hacemos debajo del agua, porque hemos hecho protestas, porque hemos salido en los medios y todo esto, ya los empleadores aquí en Santa Fe, que es en Santa Fe, Nuevo México, ya están un poquito informados. Muchas veces cuando reciben estas cartas, ellos ya como que dicen, ok, ya, no va a pasar nada, cambia la situación, pero Sí hemos tenido casos de, obviamente, que han puesto sus quejas que han tomado represalia. Entonces, la otra parte, ya cuando, después de que ellos reciben la carta, es obviamente poner la queja con la Junta Nacional de Trabajo. Entonces, el proceso que es el proceso del NLRB, ¿verdad? Para esto ya hemos tenido 3, 4, no sé, 5 juntas a llamar para poner la queja, la información, y esto es súper primordial. Lo que nosotros mandamos o ellos mandan, es una prueba para la Junta Nacional diciendo que ellos aquí decidieron ser un grupo, un comité, firmaron este contrato, ¿verdad? Y esto lo toman como prueba junto con todas sus cartas que ellos ya mandaron a su empleador. Obviamente, según mandar toda la información, lo que tengan, después de esto, pues ya sabemos, ¿verdad? El investigador llama a alguien de algún trabajador para hacer las entrevistas. Yo nada más quiero, lo demás pues ya la sabemos, ¿verdad? Lo que han dicho nuestras compañeras, ya empieza la investigación para saber si hay represalia. Lo que nosotros lo que hacemos aquí es, nuevamente, lo voy a repetir, es empoderar a los trabajadores para que ellos mismos van recolectando sus documentos, sus pruebas, incluso ellos están en súper, ¿cómo se dice? En mucha información entre ellos mismos, perdón, en grupo. Ellos siempre están unidos, perdón, esa es la palabra, unidos, y es cuando este grupo o estos comités tienen éxito. No sé, ¿hay preguntas?
Okay, thank you so much, Rayos and Gabriela. So we have a whole bunch of questions in the chat, so let's have at them. So I'll just throw out a few to begin. There's a lot, so we'll move through them quickly. I'm going to start by putting out 4. So please, you might want to jot a few notes so you remember all 4 questions. The first one is from Jorge Mujica from Mori, Chicago, and he wants to know, are NLRB agents mandated to advise workers on the Hoffman decision? Gabriel Gutierrez wants to know, has any region successfully gotten outside trainers to come into the workplace to educate workers? What sort of factors go into getting that remedy? And what if the employer refuses? Jorge comes back again and says, union organizing cannot be done during working hours, but can you do it in a non-union organizing campaign? And then one more question, and then we'll take some answers and we'll go back to the questions again. How does employment at will, Jennifer Garcia asks, how does the employment at will affect retaliation? How do workers fight against that? So let me start with Mori, Teresa, Sheila, and Rayos and Gabriela.
I'll take first jump on the Hoffman question.
Thank you.
So that only comes in, Hoffman is a case that holds that employees who don't have work authorization are not entitled to back pay or reinstatement. It's a Supreme Court case, but that we assume everybody does have work authorization, and we're not going to ask about that. So as Teresa mentioned earlier, that your work authorization status is not relevant when we investigate an unfair labor practice with respect to the merits of it. And I put into the chat a very new memo that all of our board agents now have, and we give to witnesses and we tell them about it when they call us, basically saying your immigration status is not relevant. We don't want to talk about it. So we do not automatically just tell people about Hoffman. But instead, we do tell them that they have these, the rights under the National Labor Relations Act, regardless of their immigration status. So I hope that answers the question.
Yeah, if I could jump in on that too, Maury. one of the reasons we're not, Hoffman is a Supreme Court case. It limits the remedies that we can get for workers without status. But we still can get remedies for workers without status. It's just not back pay and reinstatement. So that's number one. Number two, and to add to what Mori said, we also have a way, the reason we don't talk about Hoffman, we're not mandated to tell people about Hoffman, as Mori said, is because we assume that they were employed, the employer went through the I-9 process. We're going to assume that they did everything. And the reason we assume this is because employers will oftentimes try to use status strategically or threats of status strategically. And it's very important for us to understand the IRCA laws. I know Jessie Hahn's here and she can talk a lot about that, but employers are required to fill out certain paperwork. And if you're employed there, then we're going to assume they've done it. And we're going to assume that everything's fine. So we don't investigate immigration status either because we assume everything's on the up and up.
Okay, let's try to answer questions a little bit more quickly, just so we can make sure we get to everyone's questions. So,
Okay.
Yes, can you?
I'll
please
do outside trainers. Sorry. Get outside trainers. We have not asked for outside trainers yet. And one of the reasons we haven't done that yet is, well, we haven't thought about it. It would be interesting if we could get outside trainers. The board has actually ordered, no, the board has not yet ordered supervisory training yet, right, Mori?
Right.
We've gotten it in
settlements.
Yeah, we've got it in settlements. It hasn't been ordered yet. And one of the things that we have to do in our training is remedy the harm done. So we usually try to aim it at the unfair labor practice. So we're trying to restore the status quo through training. But I'm
I would
sure
just add that we go out and do the training in the settlement. Yeah. My region, I prefer that we require a board agent go out and do the training rather than letting the employer provide the training.
Right.
So let's go on, but let me just say, Mori, it's a powerful way to build the credibility of the organizations and to give them access to the workforce. So it's something that state departments of labor and local offices of labor standards are doing now, is contracting with worker centers to go out and do know your rights trainings. It's especially powerful when they go out to places where there's been retaliation against workers for exercising these rights. So we'd love to talk to you more about that, but let's move on to the other questions, okay?
There was one on union organizing during working hours. Could you repeat that question?
Yes, it said union organizing cannot be done during working hours, but can you do it in a non-union organizing campaign?
Mori, do you want to try to hit that one?
I think if you let sometimes there are no solicitation, no distribution rules, and as long as they're uniformly applied, they would apply here as well. But if you let employees talk about political issues and sports teams, then you should also let them talk about their working conditions during work time. But
including unions.
Yeah. I mean, the law is evolving. And I think it's kind of shifting back to being more protective of employee rights.
Yeah, we saw that in the Amazon decision, right? So that was great to see. Let me go on to some other questions. The one I don't think you addressed was Jennifer Garcia's question. How about employment at will? How does that affect retaliation?
That's a good question. It does not apply because employment at will, you could basically fire anybody for anything, but you cannot fire them for an unlawful reason. And so even if somebody is working in an employment at will situation, it's still unlawful if you fire them in retaliation for exercising one of their rights.
Okay, I'm going to now go through another 4 questions. And again, please jot notes. And I know I have some specifically for Somos, so just please be patient. And also, everyone, I want to remind you, Jessie Hahn from the National Immigration Law Center is waiting to make a presentation to us about deferred action for workers who've been involved in labor disputes. So please hold on for that. Okay, so Robert Christie asks, how common is it for undocumented workers to be deported because they made use of the protections offered by concerted activity? I ask because the biggest fear of many folks we see is further exposing themselves by organizing and their undocumented status being revealed. We want to be able to assure them that organizing and concerted activity hasn't resulted in deportations elsewhere. I read Abruzzo's November 8th, 2021 memo, but was wondering what people have experienced on the ground. Okay, Chris Williams asks, with regard to the time limit to file a charge with the NLRB, the deadline is 6 months to file a charge and to make sure the employer is served with a copy of the charge, right? My understanding is that while the NLRB will generally send the employer a copy of the charge, it is the charging party's responsibility to ensure the employer is served with the charge within the 6 months, correct? If this understanding is correct, how does the NLRB inform charging parties or organizations that support them of this obligation? I have been contacted by a number of organizations with members whose NLRB charges were dismissed because of failure to serve a copy of the charge within 6 months. Seems important to put the CP more on notice of this requirement. Robert Christie asks of Somos, can you please share the contract that you ask workers to sign to commit to supporting each other? And if you share that, we'll make sure that it gets disseminated. So why don't we take those questions and then we'll return for some more. And let me just remind people, please keep it brief.
I'll grab the 6-month one. I think that's short and easy. Yes, you're correct. It has to also be served. And our information officers should tell people that when they interact with people calling for information. But that's why participating in this outreach is so beneficial, I think, on our side as well, because I hear you, and I will now include that in the future when conducting outreach and discussing 6 months.
Yeah, there's also like a tiny little nice 8-point font on the charge itself that says it. But yes, yes, we'll make sure that people know about this more frequently. With regard to the undocumented workers, how common is it for undocumented workers or for undocumented workers to be deported because they've participated in our process? I haven't run into that yet. I've had a number of cases where the employer has made a number of threats. I think Jessie can speak more to it when she talks about deferred action. We have a number of ways of dealing with employers who make these threats, raise status, all of that, but I think Jessie Hahn can speak to that more.
And I am not aware of anybody in my region having been deported, but I am aware we just recently had a situation where a union amended out certain people who no longer wanted to participate in our case, because in their situations we did know, we were made aware, please tell your witnesses not to tell us that they were undocumented, and it would have come out.
Okay. So I'm gonna keep going with the questions. There's just a few more, and then we'll hear from Jessie Hahn. So Jim Schultz asks, if a worker files workplace health or safety complaint to the employer, and within a short period, 1 or 2 weeks from submitting, is moved by the employer to another shift and a higher paying position, even though the employer was aware that the worker needed the former shift due to healthcare or childcare reasons, could this be considered retaliation? Jennifer Garcia asks for Somos, when you talk about possible retaliation, has fear and doubt arisen with the workers, and how do you create support for them to go to the next step? Another question for the NLRB, Sandra Cisneros Peters asks, is the NLRB involved with advising deferred action in cases where the workers are being threatened with deportation? And again, we'll get to that. And Amelia Goldberg asks, what kind of causality do you need to establish between protected actions and the unfair labor practice? And Sandra Cisneros also asks, is the NLRB partnering with worker centers on field training? If so, how do we set that up? All right, that's the next thing. All right, please go.
Do you want to take the Somos question first?
Yes, please.
Yeah. Which one was that? I'm sorry.
Okay.
Yeah, we can go with the Somos question first and then hit the NLRB question.
That's
Entonces
fine.
la pregunta fue si están, se declararon como un comité y tomaron represalias moviéndoles horas, ¿verdad? Cambiándoles sus horas de trabajo. ¿Estoy correcta?
Yo creo que eso fue parte de la pregunta, Rayos, pero también otra pregunta fue, ¿cómo se cree el apoyo mutuo el comité para hablar sobre el tema que tal vez, el temor que tal vez tienen de represalia que va a pasar. Entonces, con nuestro modelo, y puedes añadir, obviamente, Rayos, con nuestro modelo, el compromiso es entre el grupo, es entre los trabajadores, porque sabemos como trabajadores y tal vez si tenemos papeles o no tenemos papeles, siempre puede haber consecuencias. Si no tienes papeles, lo tenemos muy claro que en cualquier momento, siendo indocumentado en este país, nos pueden deportar. Entonces, participar en este proceso no necesariamente aumenta el riesgo, porque si hablamos de esto públicamente y algo pasa, pues eso nos da algún tipo de protección. No sé si quieres añadir algo, Rayos, que...
No, solamente eso sí es súper importante. Por eso desde un principio hablamos de los pros y los contras, ¿verdad? Y no quiere decir que van a pasar algo mal, sino que obviamente el ser parte de un grupo o de un comité, no de un sindicato, porque no estamos en México al menos, o en Santa Fe no están sindicalizando, al menos a estos grupos de trabajadores pequeños, sino que ellos desde un momento van a saber que ellos, aunque van a tener una acción protegida, desafortunadamente, como dice Gaby, ¿verdad? Hay cosas que en realidad no están dentro de esto, pero si actuamos colectivamente, cambia la situación, cambia completamente un panorama. No puedo decir, al ser parte yo de este grupo, ya no voy a tener no sé, esta situación migratoria o lo que sea, ¿verdad? Pero si estoy dentro de un grupo, de un comité, haciendo una protesta, ejerciendo mis derechos, etcétera, o y toman represalia, ¿verdad? Cambiando entonces es cuando lo vemos de una manera un poquito diferente, es cuando se hace la diferencia, y desde ese momento los trabajadores, como en el compromiso, en las cartas, en las juntas, lo hablamos muchísimo. Pros y contras.
So let me just say, we need to move on because I want to make sure we have enough time for Jessie Hahn. But could the NLRB people please address the other questions that came up briefly?
Yeah, Mori, do you want to take health and safety and causality?
Yeah, for causality, what we need to establish a case is that the employee engaged in protected concerted activity or union activity. The employer had knowledge of that activity or was aware of it. Sometimes you can imply that the employer had animus or animosity towards that level of activity or type of activity, and there was an adverse action, so some type of retaliation. And once we have those factors, the burden shifts to the employer to prove that they would have taken the same action even in the absence of that protected concerted activity. So that's what we do in situations where the employer claims it had a different, a lawful motivation for taking the action. Teresa?
Yeah, and I think that analysis would apply to the health and safety scenario that was presented, where somebody files a claim that a health and safety claim asks for, I don't know, a reasonable accommodation or makes the employer aware and files a claim with OSHA. We would use that analysis. We'd first have to establish that OSHA, that health and safety action was protected. And I know that our general counsel has a very expansive view. So just even if you're an individual filing that could be protected because you're filing something that sits at the heart of concerns for workers, which is, their livelihood and their health and safety. And then we ask the employer to explain why you do what you did. So we'd apply the analysis that Mori.
In terms of what the employer did, moving somebody to a less convenient job, even though it paid more, yes, that would be retaliation. We do have many situations where somebody's moved to something less desirable. And right. Yes, that would be retaliation.
Right. And with regard to advising on deferred action, we are part of that. So we have an entire arsenal of things that we can do when employers threaten people regarding their status, when they try to use status, immigration status against workers, not just the workers who they're claiming have status issues, but the entire workforce around them, because a threat on status is very chilling. So we have deferred action, we have deconfliction, we can do U visas and T visas, but I'm pretty sure Jessie can talk more about that.
So I think that's our cue. The one thing you didn't answer, forgive me if you have, is this idea of doing field trainings.
Oh, yes, we would love to.
Okay, great. So we'll follow up about the field trainings. Now, first of all, thank you so much. This was incredibly helpful. And people have hung on, or most people have hung on. Please now welcome Jessie Hahn, who many of us know, an incredible resource from National Immigration Law Center, to talk with us about deferred action. Jessie?
Hi, yes, can you hear me?
Yes.
So it's so great to be here with all of these wonderful people, so many familiar faces, and thank you to Janice and Sheila and everyone who organized this. I think it's just a very timely, important conversation, and hopefully we will be seeing lots more of these cases, and they'll be really successful in helping people. So my name is Jessie Hahn. I am the Senior Labor and Employment Policy Attorney at the National Immigration Law Center. I'm based in Washington, D.C. Before I was at NILC, I actually worked for the Department of Labor in the state of New York and the city's labor enforcement agency in New York City. And so I have a presentation that's it's got two parts. The first part is focused specific, is kind of a general overview of immigrant workers and protected concerted activity. And then the second part is going to go deeper into this whole new area of work that's emerging around deferred action and kind of what we know and what we are looking forward to on that front. So, and I will also say I am not a practitioner before the board. And so there are definitely technical things about board practice that people on this call will know a lot better than me, but hopefully I'm able to kind of, compile some of the immigrant specific issues and help spark a conversation. So one thing that I will say about protected concerted activity that I have seen now happen a lot is that one of the advantages of it is that it allows workers to organize around concerns that have to do with their jobs, but to which, for situations where there aren't always kind of clear statutory entitlements or minimum standards, that they could go file a claim for at another agency. And so two really good examples of this that I think this audience will appreciate is both all of the protests that have happened around Day Without an Immigrant, right? Where that's a situation where, it depends on how the workers articulate their reasons for joining the Day Without an Immigrant protests, but there are ways to articulate it such that it can constitute protected concerted activity, and therefore they can be protected against discipline or termination for missing work in a way where normally you don't have protections against missing work for kind of an immigration protest where you are not connecting it back to your terms and conditions of employment, if that makes sense. And then similarly with COVID, and I know there's organizations on this call that have done these cases, but in the beginning of the pandemic, one of the things that was so hard for all of us was just kind of watching OSHA not do anything, right? And theoretically, this was who you would have gone to file with. And instead, it seemed like where people were actually able to get some traction was filing protected concerted activity claims around, trying to pressure their employers to improve workplace health and safety standards. So those are some of the things that stand out to me as being really important for immigrant workers, kind of important general examples of how you can use it. We wanted to talk specifically about retaliation because, of course, everyone knows it's very kind of, you know, it's everywhere. And the a couple things that I will say about this is just that there are going to be situations where you have a fact pattern where there's overlapping jurisdiction, like in the example between OSHA and the NLRB. And in fact, specifically with OSHA, the NLRB has an MOU that kind of governs a little bit how they handle cases that have overlapping jurisdiction. And there is, I'm going to include this at the end of my remarks, but there's a case handling manual that the NLRB has that if you don't know about that document, you need to get your hands on that document, okay? Because there are lots of worker centers who are not kind of labor lawyers by trade, right? They are not inside a union, they are not at a labor firm, and they are trying to make the board work for them, and they don't have the benefit of, you know, like all of the mentorship basically that the people who are inside the unions have. So I included a link to it at the end, and we'll include it in the materials that are sent around after the webinar, but these case handling manuals give you a lot of really important information about how to do these cases. And so anyway, so there's pros and cons to filing with different agencies, because different agencies, depending on their authority and their statutes, may be able to seek different kinds of remedies. Some may move faster than others. So those are things where you have to kind of know what you are getting at each of the different agencies that you're going to for retaliation cases. Specifically at the board, there's this whole issue of remedies, right? And so even before you get into the issue of immigrants and remedies, right, there's the fact that the board doesn't, well, first of all, there's the fact that they can't investigate if you don't file a charge. And then there's the fact that they can't, unlike, for example, the Fair Labor Standards Act or Title VII or some of these other kind of anti-discrimination, safety and health laws, there aren't damages or penalties that they can order the employer to pay. There's a finer gloss on that I'm sure Teresa and Mori can explain more if people want to talk more about some of the other kinds of damages. But in general, what the board does is reinstatement, back pay, and then these different types of postings, right? And so people are probably familiar, but just to reiterate, right, immigrant workers are covered under the protections of the National Labor Relations Act. They're supposed to enjoy all the same standards as people with work authorization, but the limitations come in after a violation has been found, right? So there was some kind of violation of the NLRA, and then the board has these remedies that they want to implement, and that's where you start to have the problem because of the Hoffman Plastics decision, which was a 2002 Supreme Court case where they basically found that they could not order reinstatement and they could not order back pay for someone who was not work authorized. And so the NLRB has designed a whole way of kind of handling this situation where they don't ask about immigration status. Workers should never offer this information or even kind of go close to the information. It's always better if you can, as an advocate, be the one who approaches the NLRB rather than have workers directly talking with the NLRB about anything kind of close to immigration status, because then the board can kind of talk a little bit more generally about the need for potential protections with USCIS or you know, deferred action, things like that. They don't want to unnecessarily involve themselves with specific knowledge of the specific employees and their work authorization or lack thereof, right? So another thing to understand is that if an employer is trying to inquire into someone's work authorization status, that may itself be an independent unfair labor practice, separate and apart from whatever got you to the board in the first place. And they may even consider, and you could try to urge them to refer the counsel for the employer for misconduct under both the board's rules and the State Bar Association. There's actually a really good case in California about a employer attorney who was disciplined for basically being the agent of his client, retaliation by calling ICE on workers, and they tried to shield it by saying he's the attorney, he's not the employer. It didn't work. So, and then here's the other thing is like the process. First, you're going to look at, was there actually a violation of the NLRA, right? As you go through the process at the board. And the existence of the violation first has to be established before you get into the question of what's the remedy. And the immigration status only comes up at that point in the proceeding, right? What's the remedy? And so part of the reason why you don't raise this as the worker is that if the employer doesn't raise it and the board never goes into it or has a reason to know about it, then it's not an issue in the it hasn't been raised, it hasn't been put into issue. So, leave it to the employer to actually raise it and see what they say, because they may not say something that's actually true. And then another thing to understand is that there have been instances where they've gotten what's called conditional reinstatement. And so if, for example, the person is undocumented and that is caused by like a temporary lapse in their work authorization, the board in the past has been successful in obtaining more robust relief in the form of reinstatement orders that are conditioned upon the person regaining their work authorization within a reasonable period of time. And essentially, like as soon as the employee returns with work authorization, then the employer would be required to reinstate them at that time. And one other thing on this general subject to just say is that the board does not do referrals to DHS for enforcement against individual workers. That will not happen. That never happened under Trump. It's not a thing. And one thing that is interesting is that they are starting to look at referrals to DHS for enforcement against employers for IRCA violations. That's a whole separate conversation that I think we don't have time for right now, but to try to ensure some accountability. So I only have like 5 more minutes, so I'm going to have to kind of skip several slides, and hopefully folks will forgive me. There is a lot of really interesting stuff going on in these new Jennifer Abruzzo memos that have come out. They are really trying to expand the remedies beyond what they've done in the past, and it's especially relevant for undocumented workers. I think that you should be asking for more information directly from your local NLRB office about all these things. But what they are trying to do is create more effective deterrents for employers who would be retaliating against undocumented workers or guest workers or other people who have kind of precarious forms of immigration status. Yeah, I have 23 slides and I'm on slide 9. So these are some things to think about that are just like general, this stuff has been around for a long time, right? The deconfliction MOU, what it means is if you file a charge at the board, ICE is not allowed to conduct an I-9 audit of that work site while the dispute is pending at the NLRB. And it also doesn't mean that the ICE investigators will be flagged that there is a board charge. The only time that they know is if they tell essentially the labor agencies, we want to go into this place, and then the labor agencies, no, you can't go into that place. But it's not the case that under the MOU, ICE gets the full list of all the open labor disputes. That's not how that system works. Certification for UNT visas has been going on for a long time. And what's new, of course, is this deferred action process. This has already been discussed, but I will just say I've heard from worker centers recently who've been trying to file PCA claims that they've had problems with the small employer threshold because worker centers tend to work with workers who work in smaller, outfits. And then also this whole dynamic of like, the workers still have to comply with the rules even when they're engaging in concerted activity. It's not necessarily protected, if it's in violation of otherwise uniformly enforced workplace rules. So these are just general best practices. The case handling manual we will put in the materials. There's actually more than one. The The board now has immigration coordinators. There's one for each region. You should know who they are for your region, and you should establish a relationship with that person. When you file a case, you should consider, if it's possible, starting the charge with a person whose status is not at issue, just to make your life easier. But also, you know, you will always be prepping workers not to reveal their status. And lastly, I would just say, find the lawyers in your area who are labor law experts who are willing to help you troubleshoot your cases, so that these things like the 60-day window or the notice to the employer, or, you know, the small employer threshold, or these other things that I have been seeing worker centers get tripped up around when they want to file at the board. Those are the kinds of things that if you have like a mentor basically who knows the labor law really well, they can help you troubleshoot some of those issues. Okay, so in 2 minutes.
Jessie, let me just say, people are singing your praises in the chat. And one of the things we think is that we should do another session with you. So don't worry, like, take your time, do a couple more slides, and then just know that we'll do another session with you.
Okay, cool. Yeah, because there's a lot here. So we all know that immigrant workers who speak up about labor violations at their job risk getting, you know, threats from their employers about ICE, and that this chills people from reporting violations. And for a long time, there have been efforts to get DHS to use the powers that it already has under current law to defer immigration enforcement against individual people on a case-by-case basis, based on their involvement in a labor or civil rights dispute. And so what that would mean is that a labor agency like the DOL or the NLRB could urge DHS to issue deferred action or other types of immigration protections and work authorization to workers who are involved in labor disputes. And we, I'm going to skip through these things, but, you know, there's a whole history here that people may not be aware of. And I think part of the reason why I include this is just for people to understand, like, this didn't come out of nowhere. This demand goes back to the Clinton administration. We got some traction at the end of the Obama administration, and when we're really getting traction is now. But if it seems crazy to you that DHS is going to open up a new, you know, channel for people to get work authorization and deferred action, it's not coming out of the clear blue sky. It's coming out of decades of worker organizing. So there's good language in these memos that have been signaling what's coming. And I will just say that basically, and there's more slides, but if you have an open dispute at a labor agency, and a claim has been filed and they have begun investigation, I think they probably want to be sure they have jurisdiction first. You should request a letter of support, not naming any individuals, just saying at this work site, there are people who would benefit from immigration protections. It's a short letter. It's a small paragraph. You don't have to get into details. They are turning around letters in 2 weeks at the board right now. They have turned around like 4 letters in the last 2 months like that. And I have seen the letters that have gone into the board and they've been 1 paragraph. They do not go into a whole bunch of details, and they don't require that you have threats of immigration that have already happened in your case, okay? It's an open labor dispute and it's workers who need protection, and that's the standard. And then from there, the only other thing I'll just flag is if people have prior immigration histories, you need an immigration attorney. You need to be talking with them. You need to make sure that by coming forward, you're not putting them in a worse position than they already were. But I will just say this week, we had a big victory because we got our first deferred action for a person who had a prior order of removal, and they had a final order. It was issued in absentia and they got deferred action this week. So, so we're making progress. That's like, you know, we just made some progress with ICE on that one, which is a big deal. And so we have, yeah, there's definitely a longer training to be had here.
Jessie, thank you so much. And we're going to take you up on it. We've already agreed in the chat to do a session with you, and people are very excited for it. I'll just ask you one question because we're losing people, but there's a lot of enthusiasm and appreciation for your presentation, and people are actually asking for the recording, and they're asking for the slides, and we've said we'll distribute them. But one question that we're getting from Sandra Cisneros Peters is, how do we get the USCIS moving on deferred action cases with letters that are sitting there? That's where I think worker centers are seeing issues.
So we have a group that meets every week. And then we have another group that meets every month where we are workshopping all of our cases together. And we are trying to track basically every case, every letter, how long it's been there, who needs to hear about it, how we're escalating, what's our strategy, what's our tactics. And there is a range. And I don't totally get why some of the letters are sitting there when others are getting turned around really quickly. But what I can tell you is that we have heard that in the next few weeks, they are going to come out publicly and announce 3 new memos that are going to govern this whole process. And once that happens, the whole field should change, because we have not had any guidance documents up until now. The workers have been making a way where there wasn't a way. And so what we've been told is coming is guidance from the DOL about how to request from the DOL, guidance from DHS about how to request from DHS. It's going to be in the form of an FAQ on their website. And then they're issuing guidance to all of the field adjudicators in all of the USCIS offices, field offices around the country. And I don't know if that guidance is going to be public or not. They said maybe some redacted version of it would be made.
We've got one more question and then we should end. So it's from Daniela Rosiles Torres. She wants to know, how long is deferred protection for?
So what they've been doing is issuing letters for 2 years, but the understanding is that you can renew it if the labor dispute is still ongoing. So if the investigation or like any related enforcement proceeding in court is still ongoing, then you can renew.
Okay. So let me say again, we will offer an additional session with Jessie Hahn. We will follow up with all of the requests for information and dissemination of the materials we shared today and the materials mentioned by our speakers. Thank you, everyone who participated in this call, for giving such incredible attention and for asking your amazing questions. And thank you most of all to the presenters and to the incredible interpreters who did such an amazing job of supporting us through this. So thank you, everyone, and please follow up and let us know how we can be of use and how we can put you in touch with others. Thank you. Have a good day. We'll see you all soon.